morning, ladies and gentlemen. You have found the defendant guilty of 2 counts of first-degree murder. So we are now at that second phase of the trial that you've heard about throughout your time with us, the penalty phase. And this is the time where you will be asked to consider the death penalty as an appropriate sentence in this case. As far as the state is concerned, this is not something that we take lightly. We understand that this is a solemn and somber responsibility that you have before you in this case. But there are some first-degree murder cases based on the circumstances of the murder, the background of the defendant, and the law that are appropriate for you to consider the death penalty, and this is one of those cases. During the guilt phase of the trial, the focus was on proving the elements of the various charges, the murder charges, the attempted murder charges, burglary, and aggravated stalking. Well, now, during this phase, the focus is different. As you've already heard the judge sort of explain to you what you are to consider, we are now required to prove what is called an aggravating circumstance or a factor. And that is something that is set forth in Florida statute, a circumstance or a factor that elevates or heightens a first-degree murder under the law to be able to be considered for this punishment, the death penalty. You may also be presented with mitigating circumstances during this phase. And once you have heard all of the aggravating factors and the mitigating circumstances, there will be a process, and it will be explained to you at the end, that you will go through in weighing these aggravating factors and mitigating circumstances in order to come to your decision. Now, all of the evidence that the state brought forward to you in the guilt phase, all of the evidence that supports our aggravating factors we will later be arguing to you has already been presented in the guilt phase. There was a lot of detail and additional testimony and evidence that was gone into that we did in the guilt phase, knowing that there was a possibility of a penalty phase and that we would be arguing that to you at this time. So we don't want to waste your time in presenting it again here this morning. I say that just to know that our portion of this phase will be relatively brief this morning. You will hear from a few family members of Amanda Colley and Lindy Dobbins, and that'll really be the extent of what we present here this morning. And that's not to minimize the evidence that we have in this case and that we'll be arguing to you at the end. It's just that our work proving those circumstances has already been done for you. It may be that other evidence may become relevant throughout this process, and if it is, we will present additional witnesses and testimony at the appropriate time. I want to talk to you now about the aggravating circumstances that the state is prepared to prove in this case, and you'll understand when we go through them why I say that a lot of that evidence has already been presented to you. There are 5 aggravating circumstances that apply in this case as to count 1, the killing of Amanda Colley. And there are 4 aggravating circumstances that apply to count 2, the killing and murder of Lindy Dobbins. The 4 circumstances that apply to Lindy Dobbins also apply to Amanda, and then there's an additional one for Amanda that I'll discuss with you. I'll start by talking about the 4 that apply to both of them. And keep in mind that even though legally each aggravator applies to both homicide, the evidence and the facts supporting that aggravator as to each victim may be different, and we'll point that out to you in our arguments at the end. The first aggravator in this case that applies to both homicides is that the defendant was previously convicted of another capital felony or a felony involving the use or threatened use of violence. Now, that word prior is a little misleading with this aggravator because under Florida law, that also means contemporaneous to or at the same time. And I'll explain that to you. The second one that applies to both murders is that the murders were committed while the defendant was in the commission of a burglary. The third is that each of the murders in this case was especially heinous, atrocious, and cruel. The fourth is that each of the murders in this case were committed in a cold, calculated, and premeditated manner without pretense of moral or legal justification. And so those are the four that apply to both homicides. And then as to count one in Amanda Colley, there's an additional aggravator known as the domestic violence injunction aggravator. And that aggravator stands for the fact that the murder was committed by someone who was subject to an injunction and that he killed the petitioner of that injunction, in this case, Amanda Colley. Now I want to go back and kind of explain some of the evidence that has already been presented to you as to each of these aggravators. With respect to the first one, the aggravator that I said deals with the fact that there is a prior or contemporaneous capital felony or a violent felony. The defendant has both in this case. The judge will instruct you and explain this aggravating circumstance further, but basically it means the fact that he was, as to the capital felony, the fact that he was convicted of 2 homicides. Lindy's homicide can be used to aggravate the homicide of Amanda Colley, and Amanda Colley's homicide can be used to aggravate or legally find that aggravator as to Lindy Dobbins' homicide. In addition to that, we also have the 2 attempted murders of Rachel Hendricks and Lamar Beverly. Those are also violent acts, use of violence or attempted use of violence, and both of those attempted murders are to be used in consideration in the aggravating factor against both Amanda Colley and Lindy Dobbins. The second aggravator, the fact that the homicides were committed while the defendant was in the commission of the burglary, you as the jury have already unanimously established that factor when you found him guilty of a burglary at the time of the homicides. The third aggravator, the fact that the homicides were especially heinous, atrocious, and cruel. You will hear that this means that the crimes were extremely wicked or shockingly evil. You have the crime scene evidence in the testimony and the photographs from crime scene technician Vollmer. You have the testimony from Dr. Bulick, who took a lot of time in explaining the various injuries to both victims and how those occurred. And again, in this case, you have the 911 calls that you've already heard. And those 911 calls provide a glimpse into that house, and that evidence supports that Lindy Dobbins and Amanda Colley knew the defendant was there, he was armed, he was shooting, and that their deaths were inevitable. This is obviously evidence you've already heard and has been presented to you, and it will be argued in accord with the law at the end of this case. The fourth aggravator that applies to both Lindy Dobbins and Amanda Colley is that their murders were committed in a cold, calculated, and premeditated manner. And again, those terms will be explained to you legally, their definitions in further detail below, but essentially it means that the murders were committed after a calm and cool reflection, that they were committed with a prearranged design to kill, and with a heightened level of premeditation, which allowed for a substantial time for reflection. And all of that evidence has already been presented to you in the guilt phase. The extensive timeline we walked through of the defendant's words, actions, and whereabouts on August 27th explains to you and lets you know all of the time that the defendant had to reflect and to change his mind about the plan he put in place that day. And then obviously the fifth one that I mentioned, the domestic violence injunction that can only be applied as to Amanda's death, but you already have that injunction in evidence in this case, a certified copy of it that was introduced in the guilt phase to prove the charge of aggravated stalking can now be used in this phase to prove the aggravator related to the domestic violence injunction. At the conclusion of this phase of the trial, you will find that all of the evidence the state has already put before you proves each and every aggravator beyond a reasonable doubt. The aggravators will substantially outweigh any mitigation put before you in this case. And I don't know exactly what mitigation or how many mitigating circumstances may be put before you, but I suspect it may be larger in number than the 4 or 5 aggravators that the state will prove to you. But the judge will instruct you at the end of this case that this is not a simple task of math. You don't count up 4 or 5 over here and a tally of mitigating circumstances over here and just do a mathematical equation. That's not what you're here for. This isn't an easy task. It's important work. But what you'll be instructed to do is assign weight to those aggravating circumstances and any mitigating circumstances that have been proven to you. And you're going to be asked to weigh those against each other in reaching your conclusion. Once you have had an opportunity to do that, we are confident that you will find that any one of our aggravating circumstances will outweigh any potential mitigation put before you. Nonetheless, the aggregate of all 4 and 5 of our aggravating circumstances. It is that time we will ask you, after serious reflection, deliberations, and weighing all of this evidence, to return a verdict of the death penalty in this case. Thank you.